Welcome! I am Emir, and let's look back in hindsight. This is the start of German month. Before I want to talk about German media though, I want to know, can I talk about them in the first place? You know what that means? This is another episode of the Fair Use Saga. So, this is another Law Meets Balik Tanaw. Again, note the disclaimer above. You have been warned. Babala. What is fair use? I've explained it before, in both English and Filipino. Why is fair use important? I explained it already too, in Filipino but with English subtitles. I won't repeat myself here. Let's jump right in to Germany. Now, German law is officially in German, so let me read the disclaimer. Quote, translations of these materials into languages other than German are intended solely as a convenience to the non-German reading public. Any discrepancies or differences that may arise in translations of the official German versions of these materials are not binding and have no legal effect for compliance or enforcement purposes. End quote. So, in case of any differences with the English translation, the German version prevails. This is natural. German law, German. Japanese law, Japanese or Nihongo. Philippine law, English. I don't know. Oh wait, I do know. But that's a deep legal rabbit hole to go into. Subscribe and ring the bell and comment below if you want to know more. Is there fair use in Germany? Nope. Error 404. Fair use not found. Not literally, at least. What Germany has is an extensive list of limitations to copyright, just like in Japan. And these are very specific, just like in Japan. I'd mention them one by one, but if I did that, we'd be here all day. But that doesn't mean this video is over. That doesn't mean I can't talk about German media. Because 1, German copyright law has a section on free use. And 2, Germany is a part of the European Union, so we also have to consider European law. Let's start with free use. According to the German Copyright Act, as translated by Ute Reusch, Section 24, quote, 1. An independent work created in the free use of the work of another person may be published or exploited without the consent of the author of the work used. 2. Subsection 1 shall not apply to the use of a musical work in which a melody is recognizably taken from the work and used as the basis for a new work. End quote. What does, quote, free use, unquote, mean? The German Copyright Act does not define it. According to Jongsma, citing several decisions, quote, typically, free use exists if the original characteristics of the underlying work fade away in the adaptation. End quote. Now, for parodies, Jongsma explains, quote, this is an almost impossible standard for parodies to meet, since a parody will normally need to copy some original elements in order to be recognized as a parody of the underlying work. End quote. Remember what the United States Supreme Court said in Campbell versus Acuff Rose, aka the Oh Pretty Woman case? Quote, when parody takes aim at a particular original work, the parody must be able to, quote, conjure up, unquote, at least enough of that original to make the object of its critical wit recognizable. End quote. If the free use standard is almost impossible for parodies to meet, then What more for reviews like what I do? We have to show the media we talk about, or our viewers won't understand our points. Our viewers won't understand what the toot we're talking about. Please subscribe and ring the bell to be instantly notified of Balik Tanaw / in Hindsight episodes. Please like and share this video and all my videos across social media. Do check out all of my other videos and comment. Please support the show on paypal.me/Balik Tanaw, where you can give out any amount you want, or on Patreon, patreon.com/Balik Tanaw. Patrons on Patreon get early access to videos, get to see their names at the end of each video, and get to request reviews of a movie, an album, a song, a television show, or even on one-hit wonders. Or, at the very least, they get exclusive access to posts, which no one else can. Lastly, thank you to my sibling G-G Arts for the microphone I used for this video. She also designed my avatar. Check out her work on the links in the description. Thank you. And now, what were we talking about? But there's one more thing to consider. European law. Again, Germany is a member of the European Union. So, European law applies. For our case, what's applicable is the Information Society Directive. Member states like Germany were given up to 22 December 2002 to make their laws, regulations, and administrative provisions consistent with the Information Society Directive. Important for our purposes is Article 5. Paragraph 1 states, quote, temporary acts of reproduction referred to in Article 2, which are transient or incidental and an integral and essential part of a technological process and whose sole purpose is to enable a transmission in a network between third parties by an intermediary, or b, a lawful use of a work or other subject matter to be made and which have no independent economic significance shall be exempted from the reproduction right provided for in Article 2. End quote. Paragraph 2 allows member states to pass laws which would limit the reproduction right, one of the exclusive rights of the copyright owner, as I explained before, for the cases you see on screen. This means that if any of these cases are present, then there is no violation of the reproduction right, and thus no infringement. Note that these are specific exceptions, just like in German law, just like in Japanese law. Paragraph 3 allows member states to pass laws which would limit the reproduction right and the right of communication to the public of works and right of making available to the public other subject matter for the cases you see on screen. Again, these are very specific. Paragraph 4 allows member states to pass laws which would limit the right of distribution on the same grounds for limiting the reproduction right and the right of communication to the public of works and the right of making available to the public other subject matter, if these member states indeed provide for limitations to those two rights. Again, those limitations are specific. Paragraph 5 states, quote, the exceptions and limitations provided for in paragraphs 1, 2, 3, and 4 shall only be applied in certain special cases which do not conflict with the normal exploitation of the work or other subject matter, and do not unreasonably prejudice the legitimate interests of the right holder. End quote. What does this mean? I don't know. Something amazing, I guess. Oh, but I do know. And spoilers, it's not amazing. It means that, first, one of the specific limitations is present. Second, that limitation must not conflict with the normal exploitation of the work or other subject matter. And third, that limitation does not unreasonably prejudice the legitimate interests of the right holder. This is the three-step test. That's not fair use. Fair use is very different. In the United States, fair use depends on the four-factor test. This test is flexible. It depends on the facts of each case. Europe's Information Society Directive is not flexible because the first requirement is that one of the limitations enumerated must be present. And those limitations listed are specific. As I keep on pointing out, like a broken record earlier, you spin me right round, baby, right round, like a record, baby, right round, round, round. Hey, that's not Europe anymore because Brexit. Like a broken record, parang sirang plaka in Filipino. Speaking of Filipino, let's look at Philippine law. Philippine law has fair use, which is word for word from the United States Copyright Act. But Europe's Information Society Directive's approach is also in the Intellectual Property Code. How? Section 184.1 provides for a long list of specific copyright exceptions, while Section 184.2 states, quote, "The provisions of this section shall be interpreted in such a way as to allow the work to be used in a manner which does not conflict with the normal exploitation of the work and does not unreasonably prejudice the right holder's legitimate interest." End quote. That's the same three-step test. And curiously, the Philippine law was signed into law on 6 June 1997 and took effect on 1 January 1998, even before European law. But even Philippine law is more flexible than European law because of fair use. Europe's Information Society Directive is less flexible because a specific limitation must first be present. In fact, the European law I mentioned has the effect of restricting these limitations, giving greater protection to the copyright owner. Senftleben or Senftleben, sorry for the pronunciation, please correct me. He wrote, quote, "National exceptions that are embedded in a national framework of precisely defined use privileges may further be restricted by invoking the open-ended three-step test. On the one hand, national copyright exceptions are thus straitjacketed. Their validity is hanging by the thread of compliance with the abstract criteria of the easy three-step test. On the other hand, the test itself may only be invoked to place additional constraints on national exceptions that are defined narrowly anyway. Unlike fair use provisions with comparable abstract criteria, the easy three-step test cannot be employed by the courts to create new, additional forms of permitted unauthorized use. Hence, it is impossible to realize the central advantage of flexibility that is inherent in the test's open-ended wording." End quote. Senftlebens or Senftlebens article details decisions of courts in Germany involving image search engines. Either the court, quote, "was paralyzed by an inflexible limitation infrastructure," unquote, or, quote, "followed an alternative route to create breathing space for the image search service at issue. Compare this to the United States, where the Ninth Circuit Court of Appeals ruled also on image search engines. Quote, the court grounded its analysis on the notion of transformative use, that traditionally constitutes an important factor capable of tipping the scales to a finding of fair use. Pointing out a significant benefit to the public, the court noted that, quote, a search engine may be more transformative than a parody because a search engine provides an entirely new use for the original work, while a parody typically has the same entertainment purpose as the original work. End quote. Since Section 184 of the Philippine Intellectual Property Code is similarly structured as Article 5 of Europe's Information Society Directive, Section 184 also suffers from the same problems as Article 5, as I and Senftleben have pointed out. But Philippine copyright law, the Intellectual Property Code, is better because it's more flexible, because it has fair use. A use may not meet the three-step test in Section 184, but it may still be considered fair use under Section 185. So, no fair use in Germany and Europe, huh? I wanted to talk about German media. I have two ways out. One is conflict of laws, which I mentioned in my fair use in Japan video. If any of these media have been released in the United States or any place where there is fair use, then I will argue that the copyright law of the United States or of that place applies because it benefits from the protection of that specific copyright law once it has been released there. Or two, I can always look for images under Creative Commons license. Spoilers, I will talk about Creative Commons and fair use. Subscribe and ring the bell so you won't miss it.